decision today.
Absolutely. Thank you so much for having me. So the whole knock and announce system is meant to protect privacy and property damage and to hopefully prevent violence. So anytime a search warrant is issued, police officers are supposed to knock and announce unless they get a no-knock warrant, which was the case in Breonna Taylor's case. The problem with knock and announce is that it's fairly meaningless. You know, the Supreme Court has all but gutted it. There are so many exceptions if the police are worried about evidence being destroyed or if they're fearful of escape. And then the police only have to wait a reasonable amount of time. And to some courts, that has been described as 20 to 30 seconds. I don't know if you've ever been in a deep sleep in the back of your house, but there is no way I could respond to people banging on my door in 20 or 30 seconds, get dressed, and try to look at a search warrant. So the distinction between no knock and knock and announce in some cases is just academic, because I don't think it would have mattered. The police, of course, claimed that they did in fact knock and announce, even though the search warrant that was issued gave them the right to just barge in. There were some red flags in that case, but I think one of the biggest red flags in terms of them getting that type of search warrant was that they had to justify not having to knock in the first place. And so the affiant claimed that drug dealers or drug traffickers tend to have security cameras and they have a history of fleeing, and so we need this no-knock warrant. The problem is Breonna Taylor didn't have a criminal record. Breonna Taylor didn't have surveillance cameras. And the judge involved had a stack of 5 search warrants trying to target one drug dealer, and Breonna Taylor's search warrant happened to be in that stack. So I think one of the questions we should be asking is not necessarily should a no-knock have been granted, but should a search warrant have been executed and signed in the first place if we're looking at just the 4 corners of that document. Because the 4 corners of the search warrant affidavit basically said that Ms. Taylor's vehicle was seen in front of a trap house or a known drug location on numerous occasions. It never identified what the occasions were. They never said she was seen by the car. They never saw her out of the car. They never saw her doing anything illegal. And the only other thing to justify the search warrant was that the main target, I think it was DeMarcus, forgetting his last name, but he purportedly had a package delivered on one occasion to her home. And so purportedly, if the search warrant was executed, they were going to find packages of drugs. Well, of course, we know now that the police didn't find anything. So it was certainly a tragedy. Now, I believe you asked me about the recent decision from the Attorney General. And Professor Korn is absolutely right. We've been talking back and forth on this, and there's certainly been a lot of debate and public outcry about justice for Breonna. I actually agree with Professor Korn. I think the grand jury got it right. I do believe that we need justice for Breonna Taylor. I don't think justice looks like arresting the 3 police officers based on the fact that they had a search warrant. I think more time needs to be taken into why the judge signed that search warrant. If it was a good search warrant, but the police had every legal authorization to enter the home. And we know from reports that Breonna Taylor's current boyfriend, whether he recognizes the police or not, shot at the police and struck one of the police officers. And so just a common matter of self-defense, the police were authorized to return fire. The result was horribly, horribly tragic. But they have a built-in defense. So when you're talking about manslaughter or murder charges, when the police were not only exercising their duties, but they had that search warrant, it's going to be hard. I think the only exception would be the one officer who had charges. It was Brett Hankinson, because he just seemed like a loose cannon, and they're still investigating him for some other unrelated charges. But this man actually, from what I could tell from reports, decided to walk from the front of Breonna Taylor's home where the other officers were shooting, went to the side by the balcony or patio where there was drapes or some material blocking the window, and he just shot indiscriminately. And by shooting indiscriminately, he actually penetrated neighbors' walls, and one of the neighbors was pregnant. And so they brought a civil lawsuit. And so ultimately, the grand jury said that this was reckless behavior and this constitutes wanton endangerment. Now, the outcry is that they didn't charge him with anything regarding Breonna Taylor, but based on the evidence that we have, even though I know it's disappointing for a lot of people, and I feel that disappointing, I think they made the right call.
And Professor, I had a quick follow-up because this is something someone asked me and something I was wondering as well. From that preliminary stage of them seeking the warrant, and there's information that some of the information or allegations in the affidavit was fabricated. How does that tie into possible prosecution of these officers if the foundation for which the reason they were there is rocky? Does the grand jury take that into account, or is that irrelevant?
It's not irrelevant, but it doesn't necessarily mean it's going to be a murder charge. So the detective so this was a big drug sting operation. The detective who actually swore to the affidavit was not involved in the actual execution of the search warrant. So that's one problem there. And the search warrant is available on Google for anyone who wants to look at. And it is surprisingly very similar to the other 4 search warrants involved in the case. In the search warrant, they talk about the fact that this one particular house has been a hotbed for drug activity. And I suspect that the judge who signed off on it kind of bootstrapped that information into Breonna Taylor's search warrant. I think I didn't see anything that was an obvious fabrication. The one thing that was questioned was the whole package, because according to the search warrant affidavit, the officer who claimed that Breonna Taylor, he said that he observed DeMarcus go to Breonna Taylor's home, leave her home with a package. And he suspected that that was something illegal. They never intercepted the package. They never did anything else. They just made that assumption, which law students would know that's very conclusory. He also indicated that he contacted the Postmaster General to see if any other suspicious packages had been delivered. And it is the Postmaster General who said, that's not true. We would not have answered it that way. But the problem with saying that that's a direct lie is he could have talked to someone in that office who made that conclusion. And that part hasn't been really clarified yet.